Mr. Chairman and members of the committee, thank you so much for the opportunity to testify. Twice I have had the privilege of representing this committee and its leadership in voting rights cases before the Supreme Court. Once when it was under the leadership of Chairman Sensenbrenner, and it's good to see you again, sir, and with Mr. Shabbat as one of my other clients, and once under the leadership of Chairman Conyers. It was a great honor for me to represent this committee because of this committee's key role over the past 50 years in ensuring that American citizens have the right to vote in free and fair elections. Today, you're being asked to consider whether protecting those elections requires impeaching a president. That is an awesome responsibility. But everything I know about our Constitution and its values, and my review of the evidentiary record, and here, Mr. Collins, I would like to say to you, sir, that I read transcripts of every one of the witnesses who appeared in the live hearing because I would not speak about these things without reviewing the facts. So I'm insulted by the suggestion that as a law professor I don't care about those facts. But everything I read on those occasions tells me that when President Trump invited, indeed demanded, foreign involvement in our upcoming election, he struck at the very heart of what makes this a republic to which we pledge allegiance. That demand, as Professor Feldman just explained, constituted an abuse of power. Indeed, as I want to explain in my testimony, drawing a foreign government into our elections is an especially serious abuse of power because it undermines democracy itself. Our Constitution begins with the words, "We the people," for a reason. Our government, in James Madison's words, derives all its powers directly or indirectly from the great body of the people. And the way it derives these powers is through elections. Elections matter, both to the legitimacy of our government and to all of our individual freedoms, because as the Supreme Court declared more than a century ago, voting is preservative of all rights. So it is hardly surprising that the Constitution is marbled with provisions governing elections and guaranteeing governmental accountability. Indeed, a majority of the amendments to our Constitution since the Civil War have dealt with voting or with terms of office. And among the most important provisions of our original Constitution is the guarantee of periodic elections for the presidency, one every 4 years. America has kept that promise for more than 2 centuries, and it has done so even during wartime. For example, we invented the idea of absentee voting so that Union troops who supported President Lincoln could stay in the field during the election of 1864. And since then, countless other Americans have fought and died to protect our right to vote. But the framers of our Constitution realized that elections alone could not guarantee that the United States would remain a republic. One of the key reasons for including the impeachment power was a risk that unscrupulous officials might try to rig the election process. Now, you've already heard 2 people give William Davey his props. Hamilton got a whole musical, and William Davey is just going to get this committee hearing. But he warned that unless the Constitution contained an impeachment provision, a president might spare no efforts or means whatsoever to get himself reelected. And George Mason insisted that a president who procured his appointment in the first instance through improper and corrupt acts should not escape punishment by repeating his guilt. And Mason was the person responsible for adding high crimes and misdemeanors to the list of impeachable offenses. So we know from that the list was designed to reach a president who acts to subvert an election, whether that election is the one that brought him into office or it's an upcoming election where he seeks an additional term. Moreover, the founding generation, like every generation of Americans since, was especially concerned to protect our government and our democratic process from outside interference. For example, John Adams, during the ratification, expressed concern with the very idea of having an elected president, writing to Thomas Jefferson that "You are apprehensive of foreign interference, intrigue, influence. So am I. But as often as elections happen, the danger of foreign influence recurs." And in his farewell address, President Washington warned that history and experience prove that foreign influence is one of the most baneful foes of Republican government. And he explained that this was in part because foreign governments would try and foment disagreement among the American people and influence what we thought. The very idea that a president might seek the aid of a foreign government in his re-election campaign would have horrified them. But based on the evidentiary record, that is what President Trump has done. The list of impeachable offenses that the framers included in the Constitution shows that the essence of an impeachable offense is a president's decision to sacrifice the national interest for his own private ends. Treason, the first thing listed, lay in an individual's giving aid to a foreign enemy. That is, putting a foreign enemy's adversary's interests above the interests of the United States. Bribery occurred when an official solicited, received, or offered a personal favor or benefit to influence official action, risking that he would put his private welfare above the national interest. And high crimes and misdemeanors captured the other ways in which a high official might, as Justice Joseph Story explained, disregard public interests in the discharge of the duties of political office. Based on the evidentiary record before you, what has happened in the case today is something that I do not think we have ever seen before. A president who has doubled down on violating his oath to faithfully execute the laws and to protect and defend the Constitution. The evidence reveals a president who used the powers of his office to demand that a foreign government participate in undermining a competing candidate for the presidency. As President John Kennedy declared, the right to vote in a free American election is the most powerful and precious right in the world. But our elections become less free when they are distorted by foreign interference. What happened in 2016 was bad enough. There is widespread agreement that Russian operatives intervened to manipulate our political process. But that distortion is magnified if a sitting president abuses the powers of his office actually to invite foreign intervention. To see why, imagine living in a part of Louisiana or Texas that's prone to devastating hurricanes and flooding. What would you think if you lived there and your governor asked for a meeting with the president to discuss getting disaster aid that Congress has provided for? What would you think if that president said, I would like you to do us a favor. I'll meet with you and I'll send the disaster relief once you brand my opponent a criminal? Wouldn't you know in your gut that such a president had abused his office, that he betrayed the national interest, and that he was trying to corrupt the electoral process? I believe that the evidentiary record shows wrongful acts on that scale here. It shows a president who delayed meeting a foreign leader and providing assistance that Congress and his own advisors agreed serves our national interest in promoting democracy and in limiting Russian aggression. Saying, Russia, if you're listening, you know, a president who cared about the Constitution would say, Russia, if you're listening, butt out of our elections. And it shows a president who did this to strong-arm a foreign leader into smearing one of the president's opponents in our ongoing election season. That's not politics as usual, at least not in the United States or not in any mature democracy. It is instead a cardinal reason why the Constitution contains an impeachment power. Put simply, a president should resist foreign interference in our elections, not demand it and not welcome it. If we are to keep faith with our Constitution and with our republic, President Trump must be held to account. Thank you.
And did you consider the findings of fact that the Intelligence Committee made, including that, and again, I quote, the president withheld value to Ukraine and conditioned their fulfillment on actions by Ukraine that would benefit his personal political interests?
Yes, in making the determination that the president committed an impeachable offense, I relied on the evidence that was before the House and the testimony, and then when this report was issued, I continued to rely on that.
Sir, did you review the following testimony from our ambassador to Ukraine, Ambassador William Taylor?
To withhold that assistance for no good reason other than help with the political campaign made no sense. It was It was counterproductive to all of what we had been trying to do. It was illogical. It could not be explained. It was crazy.
Yes, that evidence underscored the way that the president's actions undercut national security.
Professor Feldman, will you please explain why you concluded that the president committed the high crime of abuse of power and why it matters?
The abuse of power occurs when the president uses his office for personal advantage or gain. That matters fundamentally to the American people because if we cannot impeach a president who abuses his office for personal advantage, we no longer live in a democracy. We live in a monarchy or we live under a dictatorship. That's why the framers created the possibility of impeachment.
Now, Professor Karlan, this high crime and misdemeanor of abuse of power, was it some kind of loose or undefined concept to the founders of our country and the framers of our Constitution?
No, I don't think it was a loose concept at all. It had a long lineage in the common law in England of parliamentary impeachments of lower-level officers. Obviously, they had not talked about impeaching, as you've heard earlier, the king or the like.
And can you share a little bit about that lineage, please?
Yes. So the Parliament in England impeached officers of the Crown when those people abused their power. And if I could give you one example that might be a little helpful here, right after the restoration of the kingship in England, there was an impeachment, and, when they impeached somebody, they had to say, what were they impeaching him for? So sometimes it would be, we're impeaching him for treason or the like, and sometimes they would use the phrase high crime or misdemeanor. And there was an impeachment of Viscount Mordaunt, which is a great name to have, but Viscount Mordaunt, and he was impeached because he was the sheriff of Windsor, and as the parliamentary election was coming up, he arrested William Taylor, and I just want to read to you from the article of impeachment in front of the House of Commons, because it's so telling. Here's what Article 1 of the impeachment said. It said, understanding that one William Taylor did intend to stand for the election of one of the burgesses of the borough of Windsor to serve in this present Parliament. In other words, he was running as a member of Parliament. This is what Viscount Mordaunt did. To disparage and prevent the free election of the said William Taylor and strike a terror into those of the said borough which should give their voices for him and deprive them of the freedom of their voices at the election, Viscount Mordaunt did command and cause the said William Taylor to be forcibly, illegally, and arbitrarily seized upon by soldiers, and then he detained him. In other words, he went after a political opponent, and that was a high crime or misdemeanor to use your office to go after a political opponent.
Now, Professor Gerhardt, does a high crime and misdemeanor require an actual statutory crime?
No, it plainly does not. Everything we know about the history of impeachment reinforces the conclusion that impeachable offenses do not have to be crimes, and again, not all crimes are impeachable offenses. We look at, again, at the context and gravity of the misconduct.
And Professor Turley, you recently wrote in the Wall Street Journal, and I quote, "There is much that is worthy of investigation in the Ukraine scandal, and it is true that impeachment doesn't require a crime."
That's true, but I also added an important caveat. First of all,
sir, it was a yes or a no question. Did you write in the Wall Street Journal, "There is much that is worthy of investigation in the Ukraine scandal, and it is true that impeachment does not require a crime"? Is that an accurate quote, sir?
You've read it well.
So, Professors Feldman, Karlan, and Gerhardt, you have identified that on the evidence here, there is an impeachable act, a high crime and misdemeanor of abuse of power, correct?
Correct.
Yes.
Yes.
And Professor Feldman, what does the Constitution say is the responsibility of the House of Representatives in dealing with presidential high crimes and misdemeanors like abuse of power?
The Constitution gives the House of Representatives the sole power of impeachment. That means the House has the right and the responsibility to investigate presidential misconduct and, where appropriate, to create and pass articles of impeachment.
And Professor Karlan, what does that responsibility mean for this committee with respect to President Trump's abuse of power?
Well, because this is an abuse that cuts to the heart of democracy, you need to ask yourselves, if you don't impeach a president who has done what this president has done, or at least you don't investigate and then impeach if you conclude that the House Select Committee on Intelligence findings are correct, then what you're saying is it's fine to go ahead and do this again. And I think that as in the report that came out last night, the report talks about the clear and present danger to the election system, and it's your responsibility to make sure that all Americans get to vote in a free and fair election next November.
Professor Karlan, I'd like to direct you to the words in the Constitution, other high crimes and misdemeanors. We're still going to talk about abuse of power. Can I ask, did the Constitution spell out every other high crime and misdemeanor?
No, it did not.
Please
in part because they recognized that the inventiveness of man and the likelihood that this Constitution would endure for generations meant they couldn't list all of the crimes that might be committed. They couldn't imagine an abuse of power, for example, that involved burglarizing and stealing computer files from an adversary, because they couldn't have imagined computers. They couldn't necessarily have imagined wiretapping because we had no wires in 1789. So what they did is they put in a phrase that the English had used and that had adapted over a period of centuries to take into account that the idea of high crimes and misdemeanors is to get at things that people in office use to strike at the very heart of our democracy.
And Professor, in your written testimony, you mentioned two additional aspects of high crimes and misdemeanors besides abuse of power. You talked about betrayal of the national interest, betrayal of the national interest, and corruption of the electoral process. Can you say a little bit more about what the framers' concerns were about corruption of elections and betrayal of the national interest involving foreign powers, and how they come into play here?
Sure. So let me start with the framers and what they were concerned with, and then bring it up to date, because I think there's some modern stuff as well that's important. So the framers were very worried that elections could be corrupted. They could be corrupted in a variety of different ways, and they spent a lot of time trying to design an election system that wouldn't be subject to that kind of corruption. And there are a number of different provisions in the Constitution that deal with the kinds of corruption they were worried about. Two that I'd just like to highlight here, because I think they go to this idea about the national interest and foreign governments, are one that seems today, I think, to most of us to be really a kind of remnant of a past time, which is if you become an American citizen, almost everything in this country is open to you. You can become Chief Justice of the United States. You can become Secretary of State. But the one office that's not open to you, even though you're a citizen just like all of the rest of us, is the presidency, because of the natural-born citizen clause of the Constitution. And the reason they put that in is they were so worried about foreign influence over a president. The other clause, which, probably no one had heard of 5 years ago, but now everybody talks about, is the emoluments clause. They were really worried that the president, because he was only going to be in office for a little while, would use it to get everything he could, and he would take gifts from foreign countries, not even necessarily bribes, but just gifts, and they were worried about that as well. So they were very concerned about those elections. But it's not just them, and I want to say something about what our national interest is today, because our national interest today is different in some important ways than it was in 1789. What the framers were worried about was that we would be a weak country and we could be exploited by foreign countries. Now, we're a strong power now, the strongest power in the world. We can still be exploited by foreign countries. But the other thing that we've done, And this is one of the things that I think we as Americans should be proudest of, is we have become what John Winthrop said in his sermon in 1640 and what Ronald Reagan said in his final address to the country as he left office. We have become the shining city on a hill. We have become the nation that leads the world in understanding what democracy is. And one of the things we understand most profoundly is it's not a real democracy. It's not a mature democracy if the party in power uses the criminal process to go after its enemies. And I think you heard testimony, the Intelligence Committee heard testimony about how it isn't just our national interest in protecting our own elections. It's not just our national interest in making sure that the Ukraine remains strong and on the front lines so they fight the Russians there and we don't have to fight them here. But it's also our national interest in promoting democracy worldwide. And if we look hypocritical about this, if we look like we're asking other countries to interfere in our election, if we look like we're asking other countries to engage in criminal investigations of our president's political opponents, then we're not doing our job of promoting our national interest in being that shining city on a hill.
Professor Feldman, anything to add?
Ultimately, the reason that the Constitution provided for impeachment was to anticipate a situation like the one that is before you today. The framers were not prophets, but they were very smart people with a very sophisticated understanding of human incentives. And they understood that a president would be motivated naturally to try to use the tremendous power of office to gain personal advantage, to keep himself in office, to corrupt the electoral process, and potentially to subvert the national interest. The facts strongly suggest that this is what President Trump has done, and under those circumstances, the framers would expect the House of Representatives to take action in the form of impeachment.
Professor Feldman, did you review the Intelligence Committee report finding that President Trump compromised national security to advance his personal political interests?
I did.
And will you explain, in your view, how that happened?
The president sought personal gain and advantage by soliciting the announcement of investigations, and presumably investigations, from Ukraine. And to do so, he withheld critical assistance that the government of Ukraine needed. And by doing so, he undermined the national security interest of the United States in helping Ukraine, our ally, in a war that it is fighting against Russia. So in the simplest possible terms, the president put his personal gain ahead of the national security interest as expressed, according to the evidence before you, by the entirety of a unanimous national security community.
Sir, is it your view that the framers would conclude that there was a betrayal of the national interest or national security by President Trump on these facts?
In my view, if the framers were aware that a president of the United States had put his personal gain and interest ahead of the national security of the United States by conditioning aid to a crucial ally that's in the midst of a war on investigations aimed at his own personal gain, they would certainly conclude that that was an abuse of the office of the presidency, and they would conclude that that conduct was impeachable under the Constitution.
Professor Gerhardt, what are your thoughts on the abuse of power, betrayal of national security or national interest, and the corruption of elections, sir?
Well, I have a lot of thoughts. One of them is that what we haven't mentioned yet or brought into this conversation is the fact that the impeachment power requires this committee, this House, to be able to investigate presidential misconduct. And if a president can block an investigation, undermine it, stop it, then the impeachment power itself, as a check against misconduct, is undermined completely.
Professor Karlan, can you have an impeachable offense of abuse of power that is supported by considerations of a president's betrayal of the national interest or national security and by corruption of elections?
Yes, you can.
And do we have that here, ma'am?
Based on the evidence that I've seen, which is reviewing the transcripts of the 12 witnesses who testified, looking at the call readout, looking at some of the president's other statements, looking at the statement by Mr. Mulvaney and the like, yes, we do.
And Professor Feldman, do you agree?
Yes.
Professor Gerhardt?
Yes, I do.
Professor Karlan, we've been talking about the category of other high crimes and misdemeanors, like abuse of power. But there are some additional high crimes and misdemeanors that are specifically identified in the text of the Constitution, correct?
Yes, that's true.
What are they?
Treason and bribery.
Do President Trump's demands on Ukraine also establish the high crime of bribery?
Yes, they do.
Can you explain why, please?
Sure. So the high crime or misdemeanor of bribery, I think it's important to distinguish that from whatever the U.S. Code calls bribery today. And the reason for this, in part, is because
Thank you.
in 1789, when the framers were writing the Constitution, there was no federal criminal code. The first bribery statutes that the United States Congress passed would not have reached a president at all, because the first one was just about customs officials. And the second one was only about judges. So it wasn't until, I don't know, 60 years or so after the Constitution was ratified that we had any federal crime of bribery at all. So when they say explicitly in the Constitution that the president can be impeached and removed from office for bribery, they weren't referring to a statute. And I will say, I'm not an expert on substantive federal criminal law. All I will say here is the bribery statute is a very complicated statute. So what they were thinking about was bribery as it was understood in the 18th century, based on the common law up until that point. And that understanding was an understanding that someone, and generally even then it was mostly talking about a judge. It wasn't talking about a president, because there was no president before that. It wasn't talking about the king, because the king could do no wrong. But what they were understanding then was the idea that when you took private benefits, or when you asked for private benefits, in return for an official act, or somebody gave them to you to influence an official act, that was bribery.
And so we have constitutional bribery here, the high crime and misdemeanor of constitutional bribery against President Trump.
If you conclude that he asked for the investigation of Vice President Biden and his son for political reasons, that is to aid his reelection, then yes, you have bribery here.
And informing that opinion, did you review the memorandum of the president's telephone call with the Ukrainian president, the one where President Trump asked, I would like you to do us a favor, though, and also asked about looking into his U.S. political opponents?
Yes, I did rely on that.
And did you consider the following testimony from our ambassador to the European Union, Ambassador Sondland?
Was there a quid pro quo? As I testified previously, with regard to the requested White House call and the White House meeting, the answer is yes. Everyone was in the loop.
Did you consider that, Professor?
I did consider that, yes.
And did you also consider the findings of fact that the Intelligence Committee made, including that, and I quote from finding of fact number 5, the president withheld official acts of value to Ukraine and conditioned their fulfillment on actions by Ukraine that would benefit his personal political interests?
I did rely on that. In addition, because as I've already testified, I read the witnesses, the transcripts of all of the witnesses and the like. I relied on testimony from Ambassador Sondland and testimony from Mr. Morrison, testimony from Lieutenant Colonel Vindman, testimony for Ambassador Taylor. I relied on the fact that when, I think it was Ambassador Taylor, but I may be getting which one of these people wrong, sent the cable that said, you know, it's crazy to hold this up based on domestic political concern. No one wrote back and said, that's not why we're doing it. I relied on what Mr. Mulvaney said in his press conference. So there were, you know, there's a lot to suggest here that this is about political benefit. And if I don't know if I can talk about another piece of Ambassador Sondland's testimony now, or I should wait. Tell me.
Please talk about it.
So I want to just point to what I consider to be the most striking example of this, and the most, you know, I spent all of Thanksgiving vacation sitting there reading these transcripts. I didn't, you know, I ate like a turkey that came to us in the mail that was already cooked, because I was spending my time doing this. And the most chilling line for me of the entire process was the following. Ambassador Sondland said he had to announce the investigations. He's talking about President Zelensky. He had to announce the investigations. He didn't actually have to do them, as I understood it. And then he said, I never heard, Mr. Goldman, anyone say that the investigations had to start or had to be completed. The only thing I heard from Mr. Giuliani or otherwise was they had to be announced in some form. And what I took that to mean was this was not about whether Vice President Biden actually committed corruption or not. This was about injuring somebody who the president thinks of as a particularly hard opponent, and that's for his private beliefs. Because if I can say one last thing about the interests of the United States, the Constitution of the United States does not care whether the next president of the United States is Donald J. Trump or any one of the Democrats or anybody running on a third party. The Constitution is indifferent to that. What the Constitution cares about is that we have free elections. And so it is only in the president's interest, is not the national interest, that a particular president be elected or be defeated at the next election. The Constitution is indifferent to that.
Professor Feldman, any thoughts on the subject of the high crime and misdemeanor of bribery and the evidence that Professor Karlan laid out?
The clear sense of bribery at the time when the framers adopted this language in the Constitution was that bribery existed under the Constitution when the president corruptly asked for or received something of value to him from someone who could be affected by his official office. So if the House of Representatives and the members of this committee were to determine that getting the investigations either announced or undertaken was a thing of value to President Trump, and that that was what he sought, then this committee and this House could safely conclude that the president had committed bribery under the Constitution.
Professor Gerhardt, what is your view?
I, of course, agree with Professor Karlan and Professor Feldman. And I just want to stress that if what we're talking about is not impeachable, then nothing is impeachable. This is precisely the misconduct that the framers created a Constitution, including impeachment, to protect against. And if there's no action, if Congress concludes they're going to give a pass to the president here, as Professor Karlan suggested earlier, every other president will say, okay, then I can do the same thing, and the boundaries will just evaporate. And those boundaries are set up by the Constitution, and we may be witnessing, unfortunately, their erosion, and that is a danger to all of us.
And what can this committee and the House of Representatives do, sir, to defend those boundaries and to protect against that erosion?
Precisely what you're doing.
Does it matter? I'll ask all the panelists. Does it matter to impeachment that the $391 million, U.S. taxpayer dollars, in military assistance that the president withheld was ultimately delivered? Professor Feldman, does that matter to the question of impeachment?
No, it does not. If the President of the United States attempts to abuse his office, that is a complete impeachable offense. the possibility that the president might get caught in the process of attempting to abuse his office and then not be able to pull it off does not undercut in any way the impeachability of the act. If you'll pardon a comparison, President Nixon was subject to articles of impeachment preferred by this committee for attempting to cover up the Watergate break-in. The fact that President Nixon was not ultimately successful in covering up the break-in was not grounds for not impeaching him. The attempt itself is the impeachable act.
Professor Karlan, does it matter to impeachment that the unfounded investigations the president sought were ultimately never announced?
No, it doesn't. And if I could give an example that I think shows why soliciting is enough. Imagine that you were pulled over for speeding by a police officer, and the officer comes up to the window and says, "You were speeding, but you know, if you give me $20, I'll drop the ticket." And you look in your wallet and you say to the officer, "I don't have the $20. And the officer says, "Okay, well, just go ahead, have a nice day." The officer would still be guilty of soliciting a bribe there, even though he ultimately let you off without your paying. Soliciting itself is the impeachable offense, regardless whether the other person comes up with it. So imagine that the president had said, "Will you do us a favor? Will you investigate Joe Biden?" And the president of Ukraine said, "You know what? No, I won't, because we've already looked into this and it's totally baseless." The president would still have committed an impeachable act, even if he had been refused right there on the phone. So I don't see why the ultimate decision has anything to do with the president's impeachable conduct.
What's the danger if Congress does not respond to that attempt?
Well, we've already seen a little bit of it, which is he gets out on the White House lawn and says, "China, I think you should investigate Joe Biden."
Professor Gerhardt, your view?
I certainly would agree with what's been said. One of the things to understand from the history of impeachment is everybody who's impeached has failed. They failed to get what they wanted. And what they wanted was not just to do what they did, but to get away with it. And the point of impeachment is, it's made possible through investigation, is to catch that person, charge that person, and ultimately remove that person from office. But impeachments are always focusing on somebody who didn't quite get as far as they wanted to. It's as nobody's better than Professor Karlan at hypotheticals, but I'll dare to raise yet another one. Imagine a bank robbery, and the police come, and the person's in the middle of a bank robbery, and the person then drops the money and says, I'm going to leave without the money. Everybody understands that's robbery. I mean, that's burglary. I'll get it right. Yeah. And in this situation, we've got somebody really caught in the middle of it, and that doesn't excuse the person from the consequences.
Professors, we've talked about abuse of power and bribery. When we started, we said we would also discuss obstruction of Congress. So I'd like to ask you some questions about obstruction of Congress. Professor Gerhardt, in your view, is there enough evidence here to charge President Trump with the high crime and misdemeanor of obstruction of Congress?
I think there's more than enough. As I mentioned in my statement, just to really underscore this, the third article of impeachment approved by the House Judiciary Committee against President Nixon charged him with misconduct because he had failed to comply with 4 legislative subpoenas. Here it is, far more than 4 that this president has failed to comply with, and he's ordered the executive branch as well not to cooperate with Congress. Those, together with a lot of other evidence, suggest obstruction of Congress.
Professor Karlan, do you agree?
I'm a scholar of the law of democracy. So as a citizen, I agree with what Professor Gerhardt said. As an expert, my limitation is that I'm a scholar of the law of democracy. I'm not a scholar of obstruction of justice or obstruction of Congress.
We will accept your opinion as a citizen. Professor Feldman.
The obstruction of Congress is a problem because it undermines the basic principle of the Constitution. If you're going to have 3 branches of government, each of the branches has to be able to do its job. The job of the House is to investigate impeachment and to impeach. A president who says, as this president did say, I will not cooperate in any way, shape, or form with your process, robs a coordinate branch of government. He robs the House of Representatives of its basic constitutional power of impeachment. When you add to that the fact that the same president says, my Department of Justice cannot charge me with a crime, the president puts himself above the law when he says he will not cooperate in an impeachment inquiry. I don't think it's possible to emphasize this strongly enough. A president who will not cooperate in an impeachment inquiry is putting himself above the law. Now, putting yourself above the law as president is the core of an impeachable offense, because if the president could not be impeached for that, he would, in fact, not be responsible to anybody.
And, sir, in forming your opinion, did you review these statements from President Trump?
Well, we're fighting all the subpoenas. Then I have an Article 2 where I have the right to do whatever I want as president.
I did, and as someone who cares about the Constitution, the second of those in particular struck a kind of horror in me.
And Professor Gerhardt, in forming your opinion that President Trump has committed the impeachable offense of obstruction of Congress, did you consider the Intelligence Committee report and its findings, including finding 9, that President Trump ordered and implemented a campaign to conceal his conduct from the public and to frustrate and obstruct the House of Representatives impeachment inquiry?
I read that report last night after I had submitted my statement, but I had watched and read all the other transcripts that were available. The report that was issued reinforces everything else that came before it, so yes.
So we've talked first about abuse of power and bribery, and then about obstruction of Congress. And Professor Gerhardt, I'd like to now ask you some questions about a third impeachable offense, and that is obstruction of justice. Sir, have you formed an opinion as to whether President Trump committed the impeachable offense of obstruction of justice?
Yes, I have.
And what is your opinion, sir?
Well, based on, I've come here like every other witness, assuming the facts that have been put together in official reports. The Mueller report cites a number of facts that indicate the President of the United States obstructed justice, and that's an impeachable offense.
And in your testimony, sir, you pointed out that the Mueller report found at least 5 instances of the president's obstruction of the Justice Department's criminal investigation into Russian interference in the 2016 election, correct?
Yes, sir.
And the first of those instances was the president's ordering his then White House counsel, Don McGahn, to fire the special counsel rather to have the special counsel fired in order to thwart the investigation of the president, correct?
That is correct.
And the second was the president ordering Mr. McGahn to create a false written record denying that the president had ordered him to have Mr. Mueller removed.
That's correct.
And you also point to the meeting of the president with his former campaign manager, Corey Lewandowski, in order to get him to take steps to have the investigation curtailed, right?
Yes, sir, I did.
And you also point to pardon dangling and witness tampering as to Paul Manafort and Michael Cohen, former campaign official, former personal lawyer of the president.
Both individually and collectively, these are evidence of obstruction of justice.
How serious is that evidence of obstruction of justice, sir?
It is quite serious, and that's not all of it, of course. We know, as you've mentioned before and others have mentioned, obstruction of justice has been recognized as an impeachable offense, both against President Clinton and President Nixon. This evidence that's been put forward by Mr. Mueller, that's in the public record, is very strong evidence of obstruction of justice.
Professor Karlan, when you look at the Department of Justice Russia investigation and how the president responded to that, and when you look at Congress Ukraine investigation and how the president responded to that, do you see a pattern?
Yes, I see a pattern in which the president's views about the propriety of foreign governments intervening in our election process are the antithesis of what our framers were committed to. Our framers were committed to the idea that we as Americans decide our elections. We don't want foreign interference in those elections. And the reason we don't want foreign interference in those elections is because we're a self-determining democracy. And if I could just read one quotation to you that I think is helpful in understanding this, it's somebody who's pointing to what he calls a straightforward principle. It is fundamental to the definition of our national political community that foreign citizens do not have a constitutional right to participate in and thus may be excluded from activities of democratic self-government. And the person who wrote those words is now Justice Brett Kavanaugh in upholding the constitutionality of a federal statute that denies foreign citizens the right to participate in our elections by spending money on electioneering or by giving money to PACs. They have long been forbidden to give contributions to candidates. And the reason for that is because that denies us our right to self-government. And then now Justice Brett Kavanaugh was so correct in seeing this that the Supreme Court, which, as you know, has taken campaign finance case after campaign finance case to talk about the First Amendment, summarily affirmed here. That is, they didn't even need to hear argument to know that it's constitutional to keep foreigners out of our election process.
Professor Feldman, you were somewhat of an impeachment skeptic at the time of the release of the Mueller report, were you not?
I was.
What's changed for you, sir?
What changed for me was the revelation of the July 25th call and then the evidence that emerged subsequently of the President of the United States, in a format where he was heard by others and now known to the whole public, openly abused his office by seeking a personal advantage in order to get himself reelected and act against the national security of the United States. And that is precisely the situation that the framers anticipated. It's very unusual for the framers' predictions to come true that precisely, and when they do, we have to ask ourselves, someday we will no longer be alive, and we'll go wherever it is we go, the good place or the other place, and, you know, we may meet there, Madison and Hamilton, and they will ask us, when the President of the United States acted to corrupt the structure of the Republic, what did you do? And our answer to that question must be that we followed the guidance of the framers, and it must be that if the evidence supports that conclusion, that the House of Representatives moves to impeach him.
Thank you. I yield my time back to the chairman.
And my time has expired. I yield back. Before I recognize the ranking member for his first round of questions, the committee will stand in a 10-minute humanitarian recess. I ask everyone in the room to please remain seated and quiet while the witnesses exit the room. I also want to announce to those in the audience that you may not be guaranteed your seat if you leave the hearing room at this time.
Good luck.
And once the witnesses have left the hearing room, at this time the committee will stand in a short recess.
A little housekeeping there from Chairman Gerald.